We'll hear argument this afternoon in the Geo Group versus Menocal. Mr. Dre.
Mr. Chief Justice, and may it please the Court, the government can act only through agents, either employees or non-employee contractors. And the common law draws no distinction between public servants and private individuals engaged in public service. That makes sense. Contractors following the government's instructions are immune from suit for the same reason government employees are immune. That is, they are doing the sovereign's work. Now, to be sure, their immunity is not the same as the sovereign's. The sovereign is immune from suit unless it has waived its immunity. Its agents are only immune when they satisfy certain conditions. The most familiar example is government employees' qualified immunity. For contractors, the conditions for immunity are most famously articulated in Yearsley. Namely, what was done was within the constitutional power of Congress, and the contractor performed in compliance with all federal directions. When those conditions are met, a private party doing the government's work is immune from suit. If, however, a district court concludes as a matter of law that those conditions are unmet, as occurred here, that holding is an appealable collateral order. The Yearsley conditions are dispositive of the contractor's asserted immunity and separate from the underlying merits. And because an immunity from suit is at issue, waiting until the end of trial and taking appeal only then is not an adequate alternative. Orders denying contractors immunity therefore fit comfortably within this court's precedent, permitting immediate appeals of any number of other immunities. The court should therefore reverse the 10th Circuit's dismissal of this appeal. I welcome the court's questions.
Could you cite show us the language in Yearsley that indicates that this immunity from suit and also the basis for that? But Yearsley was just it's a short opinion, but it seems to be more about the fact that there was a takings claim which had gone to the Court of Claims, and that certainly that Yearsley, the construction company, could not effect a taking.
So Yearsley itself arises after trial, so the court doesn't have to engage the ability not to endure a suit.
Yeah.
But drawing on a common law history that includes the Piquet-Habana, Lamar versus Brown, and Murray's lessee, the court distills these two conditions. And although it doesn't say immunity, I'll concede that. 3 years later in Brady, the court says, of course, contractors obtain an immunity in connection with the work they perform for the government. And then in 2019, this court explained in Nick versus Township of Scott that Yearsley was correct to recognize an immunity from suit. And so this is a common law immunity case. And the long arc of common law cases, or as the court described it in Digital Equipment, there is a good pedigree in public law for the asserted immunity.